Hello friends, this is A.V. Ramna today before you talking a new topic, speaking about a new topic. Today I'll be taking a general topic which is not only relating to the law students but also applicable to general public. This is something regarding divorce. How a petition before the court should be presented, whether you are a Hindu, a Christian or married under Special Marriage Act. How a petition has to be presented. There are several grounds available for divorce. It may be a ground of adultery, it may be a ground of cruelty, or it may be a ground of desertion, conversion, insanity, leprosy, or venereal disease, suffering from venereal disease, or renunciation, and a presumption of death. In all such cases, a petition can be presented for a divorce. Divorce. A petition for divorce has to be presented by filing a petition before the court, and the party has to be present before the court. In addition, along with this petition, supporting document are that a marriage invitation card along with that a marriage certificate and a joint photograph of the husband and the wife is required. And supporting document of proof, address proof is mandatory to show that the petitioner resided in the premises where the petition is presented, and this petition has to be presented before the district court. Along with this, a wakalat of the advocate is required. In addition to that, you have to file an application under Section 13 of the Family Court Act and seek the permission of the court to engage the assistance of the advocate. This is the requirement of a petition before the family court, how a proceeding goes on before the family court. Once the petition is presented before the family court, then notice is issued to the opposite party. Maybe a husband has come before the court or the wife has come before the court. The moment the notice is received by the other side, he or she appears before the court, and the similarly an application, that is application under Section 13 seeking permission of the court to assist the taking permission of the court to take the assistance of legal advocate is obtained, and a wakalat is filed. And on doing so, on the first day when the matter is before the court, always there is a sphere of settlement. The court is always in favor of settling the matter before the court. So the main purpose is to settle a matrimonial dispute, and to see that the family is not disturbed. And the moment the person appears before the court, the matter is referred to mediation. The 60 days time is given for mediation, and if the mediator sees some possibility of settlement, he may seek extra time in settling the matter. If the mediation fails, the matter is referred back to the court. But if the mediation works out very good, and mediation is a very good process where parties can settle the matter and both the parties can put the litigation to an end, so that both the parties have relief, and neither party has a right to approach the court in appeal. That is, they cannot go in appeal to higher court. That is a beneficial part of mediation, if both the parties agreeing to mutual terms and conditions and have agreed to come to a mutual have to come to an understanding that this will settle the matter, whether leave amicably or get separated, and that agreement is binding upon them, and that becomes an order of the court when it comes before the court, and consent of the parties obtained, and order is passed accordingly. But if the matter is not settled before the mediation, the matter is referred back to the court, and evidence of both the parties are taken into consideration. Before that, the respondent, files his objection to the petition filed by the petitioner, and evidences are led by both the side. The petition evidence is led by an affidavit, and so also documents are filed in support of the evidence given by virtue of affidavit is supported by evidence. And similarly, the respondent has got opportunity to cross-examine the petitioner. After doing so, the respondent leads his evidence before the court, and also produces his supporting document to support his case. Once that is done, cross examination is done by the petitioner. After doing so, the court hears the matter And before, in between this, the parties have right to file necessary application. In case it happens to be a wife, she has a right to file an application for interim maintenance, seeking maintenance from the court, seeking maintenance from the husband. And it is a discretion of the court depending on the income of the husband and how the wife is situated. If she is employed, the court may consider her income and income of the husband, and if she is not, if the income which she is earning is not sufficient to maintain herself, the husband may be fastened with additional liability of income. This is how the maintenance part is decided by the court, and that is called maintenance pendent alike during the pendency of the court, during the pendency of the proceeding. Once that is done, then the order on the petition, order the main petition is passed. That is after hearing the both the parties, evidence having decided, evidence having taken into consideration, the courts will look into the evidence of the parties and pass the order. And this order is final, and this is subject to appeal because this is a decree of the court and is subject to appeal before the higher courts. So this is how a petition is filed before the court. The there is a wrong belief that the advocates and the courts take time, humpty number of time in disposing of the matter. It is once the opportunity is given to the parties to settle the matter, the parties do not come forward, or in mediation, it is the ego of the party which do not come together for a settlement point, where they have some kind of misunderstanding and more on ego, they fight on the matter. And at last, it is the family which is disturbed and not the petitioners and the respondent. That is why the purpose of mediation under section 89 has been incorporated. So the whole purpose of the family court is to see that the family relationship of family and the children is not disturbed and the concept of family is maintained. That is the whole reason the concept of family is still retained before the family court, and even the presiding officer advises them on retain the concept of family. If the petitioners and respondent are not willing to cooperate or accommodate or have not been able to cope up with this situation, they have no alternative. The court has no alternative but decide on the dispute, decide on the divorce petition, and dissolve the marriage depending on the grounds given before the court and evidence before the court and on the grounds which the parties have pleaded. This is how the proceeding before the family court goes on. Thank you. I think you have liked it. I think hope you like the video. Please like, share and subscribe my channel. Thank you.